For those many of you who don't already know me, I'm a student lawyer from beautiful British Columbia in Canada. I have the privilege to be able to work on legal issues directly affecting cryonicists there through funding provided by the Life Extension Foundation to the Lifespan Society of British Columbia, which is an organization mandated to educate the public on life extension strategies and protect access to life extension technologies. The talk that I gave in Portland is very similar to the one that I'm giving today, albeit I've made attempts to compress it even further. That said, I think that the material is more digestible now than it was in July. So for those of you for whom this is somewhat of a repeat, my apologies, but I think there's more that you'll get out of it this time. The topic is access to cryonics, legal strategies then and now. When I talk about access to cryonics, I'm not just talking about technical access or bare practical access, but meaningful access to cryonics, most meaningful access to cryonics, which in the case of Mr. Thomas Donaldson, who was diagnosed with a brain tumor, there was some concern that cryopreservation after his naturally occurring legal death may not be the most meaningful access to cryonics that might be available in an ideal world. So the quote there is from the appeal ruling in the court battles that were launched by Thomas Donaldson and Alcor on this issue, and it began more or less with the words, "Thomas Donaldson wishes to die in order to live," which I think right away gives you an idea that they didn't fully understand the issues. So the structure of my talk, I'm going to talk a little bit about the history of this legal battle, then I'm going to move into what strategy we can learn from the history, and then hopefully talk about some opportunities that might be available to us to use what we have learned from the past. So Thomas Donaldson was a mathematician, he was a philosopher, and he was also an avid cryonicist. So when he was diagnosed with grade 2 astrocytoma in 1988, and his prognosis was not very positive, he took the very brave step of petitioning for relief from California's prohibition against assisted suicide at the California Superior Court. His original petition was denied, but he and the then president of Alcor appealed that ruling. And the appellate brief, for those of you who are interested, the written argument and the appeal ruling are both available on Alcor's website. The appellant's argument, in my opinion, started off in a way that was problematic because it divided up the argument first into two separate issues. First, arguing foremost that Thomas Donaldson had a right to assisted suicide, full stop, as if that, if they were to be successful on that point, then there would be no need to consider his unique circumstances. Then in the alternative, they argued that in fact he had a right to be cryonically suspended pre-mortem in his specific circumstances. And of course, as far as all of us in the room are concerned, it's that second one that actually matters to us. And it's that second one that captures the issues of importance to us. And I believe that by packaging it along with the vocabulary of assisted suicide, it gives the court the opportunity to consider the issue of pre-mortem cryopreservation from the frame that they're familiar with, which is assisted suicide, which is done for the opposite reason. It's not a desire to live, it is a desire to seek an end to one's suffering, but it is not a desire to go on living again in the future. So it confuses the issues. This was a sign of things to come because the rest of the appellant's written argument, or most of it I should say, the next 3/4 or so, or 7/8, reads like it's just a case about assisted suicide, as if there were legal precedents already in place that would assure a win on that issue. Very correctly, I think the appellants took aim at the sort of facetious distinction between the passive withdrawal of life support and active assistance in dying, which I happen to agree is a fallacious distinction. But the legal precedents that existed at that time in California all were careful to distinguish that the courts were careful to distinguish between those two, between active assistance and passive withdrawal of life support. So they didn't really have the legal precedents available to them to prove the point they set out to prove, in my opinion. Towards the end of the appellate brief, the real issue comes to light under the heading, Plaintiff's right to direct the disposition of his body includes the right to pre-mortem cryopreservation. And I was somewhat surprised to see that at that time there was actually an apparent legal precedent for that assertion. Arising out of the Dora Kent incident, the judge in the case of Kent and Trask concluded that the adherents, including Dora Kent, had a right to pre-mortem cryonic suspension, in his words. However, this was from a lower court than the California Court of Appeal, which was hearing Donaldson's appeal, and that decision was not binding on them. So in the appeal court's ruling, they seem to start off on the right track, and they're talking about, the appellants contend Donaldson has a constitutional right to pre-mortem cryogenic suspension, but much like the appellate brief itself, they go on to analyze that issue through the familiar frame of assisted suicide, or the right to die, dying with dignity. Relying on the very same legal precedents that the appellants sought to rely on, they upheld the distinction between withdrawal of life support and active assistance in dying, and they rejected the assertion that Donaldson had a fundamental right to assisted suicide without deciding on the issue of pre-mortem cryopreservation directly, and then dismissed the appeal. So I can't claim that I've done a perfectly comprehensive failure analysis on why the appeal didn't go the way Donaldson was hoping it would go, but my working theory is that by analyzing the issue in terms of assisted suicide, the court was able to avoid having to ever consider whether or not cryonics would succeed. In Donaldson's case or in anybody else's, they were able to decide the issue entirely in the abstract, using the vocabulary of assisted suicide and the motivations, the interests involved in assisted suicide cases. One scholar said it, I think, better than I can. He says, the issue is not adequately described as a right to die case or even as a suicide case. Donaldson's cryonic suspension would be an affirmation of his life, a desire not to stop living, presumably because his life is not worthless to him. And that I think that pretty well captures it. But to understand a little bit better how the way the case was argued led, in my opinion, to the undesired result, we'll look a little closer. This is a general sketch, but a little closer at the court's reasoning process it is supposed to undertake in cases like this. First, the court will assess whether or not the right being claimed by the claimant is either a fundamental right, so one of very high importance and value to society, or whether it's what they sometimes call a mere liberty interest. Based on that classification, they will either afford the state less or more deference in their actions. So they'll either apply the strict scrutiny test. The government will have to provide very strong, compelling reasons for why they are restricting the person's fundamental right, or the government will merely have to provide a rational basis for its action or the law. And then based on that level of deference, the court will then engage in a balancing test, balancing the right claimed by the claimant against the relevant state interests at play. The previous state interests that had been recognized in cases dealing with right to die issues, assisted suicide and withdrawal of life support, were preventing suicide and preserving life, fairly self-explanatory, maintaining medical ethical standards, protection of innocent third parties like dependent children, and protection of vulnerable persons and preventing abuse. However, you'll probably recognize right away that some of these relevant state interests are not relevant at all to the case of a person seeking pre-mortem cryopreservation. For instance, preventing suicide and preserving life should have been on Donaldson's side of the scale and not the state's, because after all, what he was seeking to do was live on and avoid an otherwise permanent death. So that would not have worked in the state's side of the balancing test. It should have worked on Donaldson's side. Maintaining medical ethical standards, I think, is a little bit more debatable in terms of, or at least the state could argue that the medical profession has an interest in only permitting, treatments above a certain degree of speculation. Obviously, you know where I stand. I'm a member of Alcor, but the protection of innocent third parties was equally irrelevant in this case. Donaldson didn't have any dependent children, or it was not a consideration. And protection of vulnerable persons and preventing abuse. Again, there was no evidence that in this case there was any element of coercion, or that generally that cryonicists are under any coercion in attempting to survive through cryopreservation. So using these interests in a case about pre-mortem cryopreservation, it's not helpful. It doesn't do anything to advance the issue, to advance the argument. So the lesson learned, I think, from the result is that when in future circumstances we are in a position to make legal arguments regarding securing the most meaningful access to cryonics possible for people, either in similar cases to Donaldson's or others, we can't avoid the issue. We need to argue on the merits. Regardless of the ultimate decision, we are not doing ourselves any favors by trying to argue on the basis that the end, i.e. assisted suicide, could justify the means of the argument used to achieve a pre-mortem cryopreservation. We need to argue on point. As this scholar said, the way the issue was characterized precluded the court from addressing Donaldson's compelling reasons to seek cryonic suspension before his natural death. They were able to decide the issue in the abstract without giving any consideration to Thomas Donaldson's unique motives and interests in doing what would otherwise be an assisted suicide, but what in his circumstances was most definitely not. Now, I can't go so far as to say that this issue of characterization was completely missed by the appellants. It wasn't. I just don't think it was driven home nearly enough. The appellants did point out in the appellate brief that to pose the question in terms of murder or suicide is to begin with a conclusion that begs the questions presented and contributes nothing to an understanding of the issues. And so they've got the right idea there. It's just that after this paragraph, they went on to spend many, many more paragraphs talking all about assisted suicide and not at all about Donaldson's unique circumstances. Whereas I think if they had just argued it on its face value, on the issue of attempting to pursue a potentially life-saving treatment that is speculative and not offered by the mainstream medical community, there would have been at least a chance that the court could have found that that Donaldson's fundamental right to do that was engaged. Fast forward to the present now, 5 years after the Donaldson case, the U.S. Supreme Court decided in Washington and Glucksberg, and also the companion case Vacco and Quill, that physician-assisted suicide was not a constitutionally protected right throughout the United States, or at least based on the United States Constitution. There were some state-level decisions that followed that. However, as we've discussed earlier, or was mentioned earlier, physician-assisted suicide is permitted in both Oregon and Washington by legislation, and there was what I'm calling a technical decision in Montana that seems to leave the option available to people there, although it was not a decision based on the court deciding that people in Montana had a constitutionally protected right to physician-assisted suicide. Washington and Glucksberg had other consequences, though, more broader-reaching consequences. One is that the way the court characterized those fundamental rights that require the government to provide more compelling justification for its law are harder to get. The court said that fundamental rights have to be deeply rooted in the nation's history and tradition. So novel fundamental rights probably aren't just lying around to be picked up. Whether or not attempting to argue again for somebody to have the right to a pre-mortem cryopreservation, if the court were to characterize that quite generally as attempting to pursue a speculative, potentially life-saving treatment, perhaps they would find that that was a fundamental right that we've always had, or that has always existed in the United States history. But if they were to construe it more narrowly and look at cryonics, they'd say, well, it's only been around since the 60s, so how could this have existed throughout the nation's history? The court also said that not all important, intimate, and personal decisions are fundamental rights, and this appeared to narrow the range of what constituted a fundamental right under the Constitution after the cases of Roe and Wade and Casey versus Planned Parenthood, which seemed to give, the abortion cases, which seemed to give fairly broad meaning to the term fundamental right. So it's harder now. Oh, Canada. So I'm from Canada, so obviously this interests me. But why should it interest you? What opportunities, what strategies might work in Canada? Well, for one, there was an interesting article recently that showed that on average, the constitutions of the world are becoming increasingly dissimilar to the US Constitution. Part of that is because the US Constitution is one of the oldest ones, so that's actually a mark of pride, I think, for many Americans. And Canada's is comparatively much younger. Our Bill of Rights was only enshrined into the Constitution in 1982, so there's a huge age difference there. It's not surprising that Canada is viewed upon as a more current constitution. The trend that these authors found was driven largely by other Commonwealth common law nations, so other common law nations deriving from the English tradition, Australia, New Zealand, England itself. But those countries, the courts of those countries look to each other when they're faced with novel problems. So a decision from one court in one of those nations could have an impact on several other nations around the world. So I believe that a decision on a controversial human rights issue like the right to pre-mortem cryopreservation or other cryonics issues from a Canadian court may have more global impact than the exact same decision emanating from a US court today. Unfortunately, because of, I would wager to say, the makeup of the United States Supreme Court right now, constitutional decisions emanating from the US Supreme Court are not given the weight that they used to be. Canada's, however, are becoming a bit of a trendsetter, so for now, things change. So what's the legal context in Canada? Our prohibition against assisted suicide, which is the most relevant criminal provision here, is in a federal statute as opposed to a state-level statute, so we only have one battle to fight if we need to fight it. And it's at the federal level. The leading case in 1993 upheld the constitutionality of that provision, but there was another more recent run at the law in 2012. That has only proceeded so far as the British Columbia Supreme Court at this point, and unfortunately the woman who was the prime plaintiff in that case, Gloria Taylor, who had ALS, she has since died. So it's not clear at this point whether or not that case will continue up the rungs of appeal to the Supreme Court of Canada, as I think it was intended to do. So we're not entirely sure what the result will be. But the decision at the British Columbia Supreme Court struck down the prohibition against assisted suicide. So there is certainly a live issue to be decided in Canada. Pardon me. Our equivalent of the Bill of Rights is called the Canadian Charter of Rights and Freedoms, and it enshrines, among many other things, the right to life, liberty, and security of the person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice. The principles of fundamental justice are not defined elsewhere in our Constitution, so the court has had to elaborate. And then all of the rights in the Charter are subject to the reasonable limits clause, reasonable limits that can be demonstrably justified in a free and democratic society. And again, the Charter doesn't elaborate on that, so the court has had to come up with its own tests. So first, we're looking for the deprivation of a particular right or the engagement of that right, either the right to life, liberty, or security of the person. Security of the person referring most intuitively to physical intrusions, but it's also been accepted that significant psychological trauma would qualify as engaging one's security of the person. Once there has been a deprivation found by the court, then we're looking for the principles of fundamental justice. Some of the ones that have been recognized by the courts in Canada are that laws should not be arbitrary, that laws should not be overbroad, they should not proscribe behaviors which are not morally blameworthy, and that the effects of laws should not be grossly disproportional to their objectives. Once those stages of the test have been met by the claimant, by the plaintiff, the burden switches to the government to defend its law. And the test that the courts have designed in order for it to do that is that the government must prove that the law has a pressing and substantial objective, that it's rationally connected to that objective, or that what the law does is rationally connected to that objective, that the law minimally impairs the claimant's right, and then they engage in a final proportionality test, which is similar to the balancing test performed by US courts. So in the case of our argument regarding access to pre-mortem cryopreservation, one formulation of the argument I've suggested there is that cryopreservation prior to legal death by quote-unquote natural causes, at least in the case of a cryonicist with a brain-threatening disorder, is a protected right under Section 7 that is unjustifiably infringed by the application of the prohibition against assisted suicide. So going through that test, I would say arguing that the right to life is engaged is an argument that should be made in order to be arguing on the merits, to not be avoiding the issue. This is what we believe. We do believe that the right to life is engaged by one's ability to meaningfully access cryopreservation. However, it relies on the court accepting that cryonics does present a chance of succeeding, a chance that is enough that they should bother getting involved. So it's a difficult argument to make, but it's one we should make. I think we have a stronger chance of getting in under the head of liberty because unlike the narrowing of the definition of a fundamental right that has happened in the United States that I referred to earlier, right now the definition of liberty in Canada is very broad. I won't go through the quote there, but it's still quite broad. And, but the other thing is that we know that security of the person, it has already been found by the Supreme Court of Canada that security of the person is engaged by the prohibition of assisted suicide, whether it would be a cryonicist or anybody else seeking to procure assistance in a suicide. The principles of fundamental justice that are relevant here are that the prohibition is intended to protect the lives of the vulnerable, but here we have vulnerable people who are being prevented from trying to save their own lives. So it catches non-morally blameworthy behavior, and that if the court accepts that there is a chance of cryonics succeeding in this person's case, however small that chance is, by preventing them that meaningful access to cryonics, they're being denied what could be a very long life on the other side, and that is vastly disproportional to the objective, which is to prevent permanent death in people who are very vulnerable and are considering suicide. The reasonable limits test, the government would have no difficulty proving that it has a pressing and substantial objective, that that objective is connected to the law itself. Whether or not the court would find that the law was minimally impairing of the cryonicist's right will depend in part on the court's assessment of the probability of cryonics succeeding. So it isn't a slam dunk argument in this particular case, but I'll get to the next argument, which I think is stronger. If the court gets to the final proportionality test, we might argue that as time goes on, the numbers of cryonicists that are afflicted by brain-threatening disorders is possibly going to increase. So more and more of us will end up being denied most meaningful access to cryopreservation. The government might reply that even if cryonics works, it won't be today's patients. It'll be some time in the future, the patients that are preserved in optimal circumstances then. But I think that the apt rebuttal there is that these kinds of legal impediments discredit cryonics, hampering investment, hampering development, or at least slowing it down. So that logic is circular. However, we have an alternative argument in Canada based on freedom of conscience and religion, which is written a little broader than the US equivalent, which only explicitly describes free exercise of religion. Another limitation of the free exercise clause is that as of today, or as of now, laws that affect or are written to affect everybody equally don't engage the free exercise clause. However, that was a very controversial decision of the court in 1997. Some states have since legislated back to the old test, where even laws of equal application that affected people differently in their exercise of religion could seek the protection of the free exercise clause. But in Canada, it's open season. However, the word conscience seems to have been put in Section 2A for a reason, and there are some good bits of legal precedent where the court has said, you know, it wasn't written as freedom of religion for a reason. It was intended to include conscientiously held beliefs and manifestations of those beliefs that are not of traditional religious origin and do not fit in the box of religion, as I believe cryonics does. At least for, if you view cryonics in the general, it is not an organized religion. That's not to say that there aren't cryonicists who have organized into religious groups, but if we were to describe cryonics as generally as possible, we're not at this point an organized religion. I like Justice Wilson's statement there. She says, conscience and religion should not be treated as tautologists if capable of independent, although related meaning. You know, the Parliament would not have enacted freedom of conscience and religion if they didn't mean for conscience to have a different meaning from religion. And in more recent cases, not at the Supreme Court of Canada, at the federal court level, it has been discussed that, in fact, freedom of conscience enshrines protection for secular analogs to religion or secular moralities. So a person doesn't need to be of a religious group that prefers vegetarianism in order to have a protected right to vegetarian meals if they're inmates in a prison. You can be just an ethical vegetarian with no religious affiliation. So I think that this gives us the opportunity to argue that cryonics is a secular analog to religious burial practices. I can't remember who said it, but somebody once mentioned that cryonics is a bit like selling crack on someone else's turf, in that this is the traditional role of religion, is to deal with the handling and disposal of human remains. But you know, here that actually works in our favor, because we can say we're not a religion, but we're adjacent to religion. We don't fit in the same box, but we fit in a box that is of equal status under the Canadian Charter and should be afforded equal protection. The great advantage of an argument under Section 2A is that the likelihood of cryonics succeeding isn't relevant. It's the subjective belief that matters. One challenge we face is that most other major world religions do not promote early departures for the afterlife, and that is something where attempting to get pre-mortem cryopreservation differentiates us. In the interest of time, I'm going to continue forward. So, uncharacteristically patriotic of me. Land of opportunity, Canada. To close, I'll say I believe that Canada's constitution at this point offers broader and more points of entry for cryonics legal challenges, and I believe that a positive precedent emanating from a Canadian court would carry weight beyond our borders. And for that reason, I think that Canada represents a ripe opportunity for cryonics legal advocacy. I also want to point out that these same strategies could be used against other laws that impede cryonics. And the weaker that law's objective, the more targeted at cryonics it is, the weaker its drafting, I believe the greater the likelihood of the success of such a challenge. Some of you may be aware that in BC we have a law that appears to prohibit the sale and marketing of cryonics arrangements. That's the kind of thing I'm talking about. And I want to thank the Lifespan Society of British Columbia and particularly the Life Extension Foundation for providing the funding that is enabling me to work on that very issue. I also want to thank, in particular, the board of the Lifespan Society of British Columbia, members of whom are here today, in particular Jeff Schmigelski, who provided invaluable stimulus funding so we could start the organization up this summer, and Bill Falloon of the Life Extension Foundation for working with me to make our plans going forward possible. And I also want to thank Alcor very much for giving me the opportunity to speak. And I just want to close with that quote from Mr. Donaldson: "If we lose this battle now, I'm sure that we'll come back again. And again, until we win. Thank you.